Welcome to the Deep Dive. Today we're getting into something really important for renters: eviction defense. We'll be looking at common landlord tactics and, crucially, how tenants can fight back.
That's right. It's a tough situation many people face.
Yeah, absolutely. We've pulled together information from various guides and legal sources. Our goal here is pretty simple: equip you, the listener, with knowledge about your rights and, real steps you can take if you're dealing with difficult landlord issues.
And that knowledge is power, especially in these situations. As an attorney with Martinez Law Center in Santa Ana, we see this daily. We focus exclusively on helping tenants with eviction defense, unlawful detainers, they're called, and other housing issues across Orange County, Riverside, San Diego, and Los Angeles.
Right, and exclusively tenants. That's important to note. Your website is martinezlawcenter.com.
That's it, martinezlawcenter.com. We're solely focused on the tenant side.
Okay, perfect. So let's dive in. A term we hear a lot is landlord harassment. What does that actually mean? What should tenants be looking out for?
Well, landlord harassment, it's basically actions a landlord takes that are really designed to make your living situation intolerable or to, illegally force you out.
Okay, so it's intentional.
Exactly. And it's illegal. Think about things like frequent unnecessary inspections. Maybe they give notice, maybe they don't, but it feels constant.
Like they're always finding a reason to come in.
Right. Or just entering your apartment without permission or proper notice, unless, of course, there's a genuine emergency like a fire or a flood. That's different.
Gotcha. What else falls under this harassment umbrella?
A big one is maintenance neglect, intentionally delaying or just flat out ignoring repair requests.
So making the place uncomfortable or even unsafe on purpose.
Precisely, to pressure you to leave. We also see things like interfering with utilities, shutting off the water or electricity. That's a serious one.
Wow, okay. That's definitely crossing a line.
Absolutely. And then there are threats and intimidation. Any kind of aggressive behavior aimed at making you move. Even excessive communication, like constant emails or calls about trivial things, can sometimes rise to the level of harassment if it's creating a really stressful situation.
That makes sense. And what about locks?
Oh, yeah. Changing the locks without giving you keys. That's an illegal eviction tactic. Plain and simple. It's essentially locking you out.
And rent increases. Can they be harassment?
They can be, yes. If they're frequent, seem totally unjustified, or clearly target you specifically to, price you out of your home. It depends on the pattern and local laws, of course.
It sounds like there are many ways this can happen, but it's also important to know what's not harassment, right? Like legitimate landlord actions.
Definitely. Landlords do have rights and responsibilities. Making necessary repairs to keep the place safe and habitable, that's required, not harassment.
Good.
Enforcing lease rules fairly for everyone, also fine. Communicating about normal property management stuff is expected.
And rent increases, if done properly.
Right. If they give proper legal notice, follow local laws like rent control if applicable, and apply it fairly, a rent increase isn't harassment in itself. And of course, initiating a legal eviction process for a valid reason, like not paying rent after being properly notified, is their right. The key difference is legality and intent.
So legality and intent, that makes sense. If a tenant suspects harassment or gets an eviction notice, what should be their very first move?
Document everything. I can't stress this enough. Write it all down. Dates, times, what happened, who was involved, any witnesses. Keep every single text, email, letter.
Create that paper trail.
Exactly. Then pull out your lease agreement. Read it carefully, understand your rights and what you agreed to, and crucially, learn about your rights under the law, federal, state, and especially your local city or county laws.
Which laws are most relevant?
Well, federally, you have the Fair Housing Act that prohibits discrimination. The ADA requires reasonable accommodations for disabilities. The Fair Credit Reporting Act affects screening. But state and local laws are often where the day-to-day stuff is defined.
Like landlord-tenant acts?
Yes, covering security deposits, lease terms, maintenance duties, eviction rules. Some areas have rent control or stabilization. There are specific habitability standards, minimum conditions for a safe place to live. And very important, rules about proper notice for entry, rent hikes, or ending a lease, and the specific legal steps for eviction. These vary a lot by state and even city.
So knowing your local rules is critical. What else after documentation and knowing your rights?
Communicate with your landlord in writing whenever possible. Again, it creates that record. If there's a dispute, sometimes mediation can help resolve things without going to court.
Mediation, okay.
But if harassment continues, or especially if you get an eviction notice, you really need to consider legal action. Talk to a lawyer who specializes in tenant law.
Like the Martinez Law Center, focusing on tenants in Southern California.
Precisely. Someone who understands unlawful detainer defense in your specific area, Orange County, Riverside, San Diego, LA. Getting advice early is key because eviction cases move fast.
Let's talk about that eviction process. It's not just the landlord telling you to leave, right? It's a formal legal thing.
Absolutely. It's a court process. Here in California, it's typically an unlawful detainer lawsuit. And like I said, they move very quickly. The first thing you'll get is a written notice.
What kind of notice?
It could be a 3-day notice to pay rent or quit, or maybe a 3-day notice to perform a covenant, or quit meaning fix a lease violation, or sometimes just a 3-day notice to quit for serious issues. You must understand the reason stated and the deadline.
And calculating that deadline is crucial.
Extremely. The deadlines are strict. You need to know exactly how many days you have to respond or act according to California law, including how the notice was delivered. Missing a court deadline can mean losing your case by default.
So once you get that notice, what are the options?
Okay, basically, you can move out by the deadline. If it's something you can fix, like unpaid rent or a specific violation mentioned, you might be able to cure the default within the notice period, pay the rent, fix the issue.
Or fight it.
Or fight it. And to do that, you generally need to file a formal response, usually called an answer, with the court before the deadline expires. This is where having legal help is really beneficial to ensure it's done correctly and raises the right defenses.
What are some of those common legal defenses against eviction in California?
There are quite a few. One is improper notice. Maybe the notice itself was flawed, didn't give the right amount of time, or wasn't served correctly according to law.
Okay, technicalities matter.
They really do in eviction law. Another big one is retaliatory eviction. This is if you believe the landlord is evicting you because you exercised a legal right.
Like complaining about needed repairs.
Exactly, or reporting code violations. If you did something like that recently and now suddenly you're facing eviction, it might be retaliation, which is illegal in California.
Well,
if the landlord didn't follow the correct legal procedures during the eviction process itself, that can be a defense. A major defense is breach of the warranty of habitability.
meaning the landlord failed to keep the place livable.
Yes. Serious issues like mold, major pest infestations, lack of heat or hot water, structural problems that the landlord knew about but didn't fix. You can argue you shouldn't have to pay full rent or even any rent under those conditions.
That seems fair.
Also, illegal discrimination is a defense if the eviction is based on race, religion, family status, disability, or another protected characteristic under fair housing laws. California also has specific protections for victims of domestic violence, sexual assault, or stalking in certain eviction situations.
Are there rules about why a landlord can evict?
In some places, yes. Cities with rent control or eviction control often have just cause requirements. This means the landlord needs a specific, legally accepted reason to evict, especially for longer-term tenants. They can't just decide they don't like you anymore.
And just to reiterate, changing locks, shutting off power.
Never legal. That's called self-help eviction, and landlords absolutely cannot do that in California. They must go through the court process.
Okay, so if it does go to court, what should a tenant do to prepare?
Gather all that documentation we talked about, the lease, letters, emails, photos, repair requests, witness information. Organize it clearly. Think about your testimony, what you need to tell the judge. Understanding the basic court procedures helps too. Again, having an attorney helps navigate this.
This is a lot for someone to handle, especially under stress. What if someone can't afford a lawyer? Are there resources?
Yes, there are. Look for local legal aid societies or pro bono programs. These offer free or low-cost legal help to eligible individuals. Tenant unions and community organizations can also be great sources of support and information. Think groups like the LA Tenants Union or websites like justshelter.org can sometimes point you in the right direction.
What about help paying rent if that's the issue?
There might be emergency rental assistance programs still available, though many pandemic-era ones have wound down. Checking resources like the Consumer Finance Protection Bureau's Help for Renters Guide, calling 211, or looking at USA.gov's Help with Bills page can be starting points.
Good to know those options exist. We focused on tenants, but briefly, what should landlords do to avoid these kinds of lawsuits?
Well, fundamentally, know and follow the law. Provide proper notice for everything. Document their actions, too. Keep the property well maintained. Respect tenant privacy. Charge fair rent and handle increases legally. Communicate clearly and respectfully. And if eviction becomes necessary, follow the legal procedures to the letter. It protects everyone.
Absolutely. Well, this has been incredibly informative. Understanding tenant rights, recognizing harassment, and knowing these defense strategies seems like the essential foundation for housing security.
It truly is. Being informed is the first most powerful step. And remember, for tenants specifically in Orange County, Riverside, San Diego, or Los Angeles facing eviction or harassment, our firm, the Martinez Law Center, focuses exclusively on representing you. You can find us at martinezlawcenter.com.
That's martinezlawcenter.com. So wrapping up, understanding these common tactics and defenses is clearly your first line of defense, but actively engaging with your rights, maybe connecting with tenant groups or seeking legal advice when needed, that seems key to ensuring fair housing overall. So a final thought for our listeners, what steps will you take now to better understand and exercise your rights as a tenant? Thanks for joining us for this deep dive.
Call now 714-442-9741. Thank you.